COBRA, or the Consolidated Omnibus Budget Reconciliation Act of 1985, applies to group healthcare plans. Basically, what it argues is that um, employers with 20 or more employees on a typical working day in the previous calendar year can offer their employees up to 18 months of covered insurance post-termination at the retail rate. Basically, what that means is instead of you paying as an individual what those insurance rates would be, you could pay the retail rate that your employer pays. So basically your group rate, which is usually deeply discounted because there's volume purchasing and volume behind it. So when you are let go, terminated, whatever it is, you're eligible to buy the insurance for up to 18 months. Now, this could be $1,000 a month. It could be $500 a month. I don't know. It depends on the employer and depends on the plan. I know that under the Affordable Care Act, there is a marketplace for a lot of benefits too. So COBRA might not make sense. It might be cheaper for you to get your benefits in the marketplace. But nonetheless, the offer is there to get it through your employer. So at least you don't have a change of insurance and you can continue using your existing insurance rather than having to change your insurance. But basically, it gives participants and their beneficiaries the right to maintain their coverage that was lost because of a change in circumstance. It's covered at your expense. The employer doesn't pay it; you pay it. You pay whatever you used to pay, as well as what the employer's part was for that insurance, so that you have that. HIPAA, or the Health Insurance Portability and Accountability Act, promotes standardization and efficiency in the healthcare industry by protecting individuals from discrimination based on their healthcare status, creating a uniform system for processing, retaining, and securing healthcare information so it is secure, and it protects the privacy of individuals with respect to their healthcare data and the sharing of that data. And so what the issue is that we want people to feel like they can continue to have their healthcare insurance and not lose their insurance and lose their benefits if they have to change employers. In terms of the privacy rules, it addresses the permitted and prohibited uses and disclosure of health information by organizations that are subject to them. The important thing is that HIPAA requires the employer as well as all healthcare professionals to make sure that they are keeping your health information private and only shared with those with whom you give permission to do so. There's a general obligation of covered entities, and that requires them to notify patients of their privacy rights and explain how the health information is used or is going to be disclosed by the organization or its associates. ERISA allows employers to reduce or modify their employee benefits, except under certain circumstances. For example, it's prohibited by contractual obligations. So if you have a collective bargaining agreement, that's just not an option then to change it. It must treat similarly situated plan participants alike. So you can't treat people differentially under your plans. ERISA claims may be asserted under the Age Discrimination Act as well. And if you remember at the end of the chapter 12, I believe, where we talked about age discrimination, there are some ERISA claims where we may treat older workers differently than we treat younger workers. And so there are some limitations to that as well that we should be aware of. So our management tips. Number one, ensure that all employees are correctly classified so that the appropriate FLSA provisions are applied. Again, making sure we classify who is exempt from overtime, who is eligible for overtime, and making sure we have that clear, because if we have people misclassified, that's going to be a problem. Wages and hours comes after you, and it can create all sorts of extraneous costs that we shouldn't have to deal with. Make sure you're paying people fairly, and make sure we have people properly classified. Be sure to include all appropriate time and wages, such as donning and doffing time. So basically, time that it takes people to take off their PPE or their uniforms and put it back on, that's also included as appropriate time to be paid. Know that the Obama administration tightened up enforcement of wage laws, so make sure the laws are handled appropriately. So under the Obama administration, the wages and hours audits are much more strict. There's a lot more enforcement, and so if there's complaints to be made, know that the company that Department of Labor is coming after you to investigate. So, and these are pretty tight laws. Check the status of employees carefully before granting or denying FMLA. You have to make sure that you are eligible to give leave under the FMLA, and making sure that you have clarity as to whether or not someone is actually an employee versus they are an intern or some other category, to make sure that you are giving the benefit appropriately and not inappropriately. Also be aware that the Obama administration clarified the coverage of sick child laws to gay and lesbian caring for children of their partnership, so that what that means is if you are in a same-sex relationship, unmarried, and if you have a sick child, your partner can care for those children, and you're not going to be discriminated against because of that. The Bush administration extended the FMLA laws to better cover members of the military and their families being cared for during deployment or after returning with an injury. Make sure all of your communication about your benefit plans are clear and written in a way that a reasonable person would understand, which means you don't write it in legalese, you write it in clear, concise, 8th grade level language, because your workers oftentimes on average don't know, have a capacity to read and understand beyond 8th grade reading level. Under the PPA of 2006, you may have additional communication requirements if you're a public company, particularly regarding the divestiture of your account, divestment of your account, so that it's not just in one fund, but it's in multiple funds. Individuals acting as officers and employees who are performing fiduciary acts on behalf of a corporation that is a fiduciary should be aware of the potential for a broad-scale adoption of an expanding definition of fiduciary that is tending to include them. So what that basically means is the definition for a fiduciary is going to change, and we want to make sure that we have clarity exactly what it means to be a fiduciary, what are the standards that you're going to be held to, and who can and cannot be a fiduciary.